Laura, what do we know right now?
A really consequential decision has just been handed down. Paula Reed, the court has made a decision.
This is a win for former President Trump. Here, the Supreme Court has reversed a ruling from the Colorado Supreme Court that would have removed former President Trump from the ballot under Section 3 of the 14th Amendment, the so-called insurrectionist ban. Now, this is very much what we expected based on what we saw about a month ago during oral argument. Justices on both sides of the aisle appeared skeptical of Colorado's argument that Trump could be removed by the state under the 14th Amendment. So this is a huge win. It means that former President Trump will appear on the primary ballot. And this applies not only to Colorado, but also to states across the country. Because as we've seen, many states have tried this way of removing Trump from the ballot. It was considered a novel, long shot way to bump Trump out of eligibility for the White House, but we've only seen Colorado, Maine, and Illinois actually remove him. But here, the Supreme Court, as you know, the final word on constitutional questions, saying no, it is up to Congress, not the states, to do this. So an enormous win for former President Trump.
This is so significant, Paula. We knew in the 2.5-hour argument that was had that they were leaning in this direction. They asked the question, if you remember, the moment in time of, well, why should Colorado be the one to decide for the rest of the nation a matter of such consequence? And there was some pushback on whether a state could actually do this. It seems like they want Congress to actually make the decision because of ambiguity, maybe a little bit of vagueness, but this is very important because he was already still on the ballot, as you know. But the idea of them saying this is for Congress to look at, not us, means they don't want politics in the Supreme Court right now.
That's exactly right. And even though I'm sure they'd love to avoid all of these Trump-related cases, this is the first of at least 2 big Trump-related cases they're taking down.
Because immunity is still on the horizon.
Exactly. In a month and a half, we'll be back on April 22nd. They're going to hear oral arguments about whether former President Trump has immunity to protect him from the special counsel's federal election subversion case. But let's look at the timing here, right? It was almost a month ago that we were here for oral arguments. This was a case that they were considering on an expedited basis. I don't know about you, but I was a little surprised that it took them a month to unanimously do what we expected them to do.
Especially because they took the case up very quickly, right? It wasn't that they were, in the case of immunity, they said 7 weeks from now we'll hear something. In this case, they said we're going to hear it pretty quickly. They had a pretty easy turnaround. But this is the day before Super Tuesday as well. He's already on the ballot. As you mentioned, other states are wanting to see if they have a leg to stand on here. But Paula, the idea that the Supreme Court was going to make this decision was not so shocking. But they took that case up in the first instance, or some was surprising.
It was surprising because so many people thought this was such a novel legal theory that you weren't really going to successfully be able to remove Trump based on this obscure provision of the 14th Amendment that was enacted after the Civil War. But then we saw in the state of Colorado, even the courts within that state were split on whether this applied to presidents. But once you got that Supreme Court, a Colorado ruling that removed him, it really seemed inevitable that the Supreme Court would have to take this up, because even in states that had tried this and they didn't remove him, they left the door open. And without the Supreme Court clarifying this question, we would likely see litigation and arguably a lot of chaos and confusion throughout the presidential contest. So this also, of course, applies to the general election. And for anyone that's confused, former President Trump will appear on primary ballots, and assuming he is the nominee, as we expect him to be, on the general election ballot. Very much expected, but an enormous win for the former president.
It really is. And remember, to go back, it was a trial court in Colorado who made a finding surrounding insurrection without having an actual jury trial. He has not been charged with insurrection, not been convicted of insurrection in a criminal proceeding. The Colorado Supreme Court was the one that said, yes, actually he should be removed from the actual ballot. Now, Paula, though, this is going to suggest that because there's been no finding, there's been no ruling or conviction, this might stand across the nation.
Yeah, that's what we expect, that this will be the final word. Because again, when you saw even within the state of Colorado, the courts didn't agree, but the highest court did remove him. We also saw in Maine they removed him, and Illinois as well. But one of the many arguments that Trump's lawyers made when they were here at the Supreme Court is that they insist that he didn't engage in an insurrection. And as you remember, the justices kind of stayed away from mentioning the former president's name, but also this larger question of insurrection. Instead, it appears that they focused more on whose role is it to determine who gets removed from a ballot. And here, not surprisingly, they determined that it is Congress, not the states, that can remove potential candidates from the ballot.
Jim, a really consequential moment today. The Supreme Court finding that he should still be on the ballot, will still be on the ballot, has not been disqualified. And again, they found the exit ramp that many thought they were looking for. It was apparent.
Yeah, absolutely, Laura and Paula, and they're doing this on the eve of Super Tuesday, which makes sense, and I guess gives us some sense that the Supreme Court is looking at the political calendar, not just the legal calendar. All right, Laura and Paula, thank you. Let me go. Joan Biskupic is on set with us, as well as Dana Bash and Ellie Honig. Joan, your sense of this?
Well, first of all, it's 9-0 to reverse the Colorado Supreme Court. So former President Donald Trump will remain on the ballot and other state ballots. But the justices actually split on how far to go. The majority decision, written as a per curiam, likely by the Chief Justice of the United States because it's unsigned, gives much more authority to Congress about when someone should be disqualified. And Justices Barrett, and then the three liberals write separately. And what's key here is justices. I'm listening to two different things. Excuse me for a second.
It happens.
I was listening to two different conversations, but I'll listen to ours first.
Please.
Okay, this is the important part, that even though they came out and gave us something unanimous that's very useful in the political scheme, especially for tomorrow, for Super Tuesday, it shows how divided the Supreme Court still is, because the three liberals broke off and said, you majority are going too far in terms of how you would dictate the rules for future disqualifications. And again, it was the three liberals specifically writing on this, Justices Sotomayor, Sonia Sotomayor, Elena Kagan, and our newest Justice, Ketanji Brown Jackson. Now, Justice Barrett, one of Donald Trump's appointees, the third one, in fact, split off a bit also, but not joining the liberals.
Interesting. And Ellie, I just want to read, it looks like page 13 of this. It says, for the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states.
Right.
The judgment of the Colorado Supreme Court therefore cannot stand. So they're saying essentially that Congress has to make this decision whether there are insurrectionists who need to be kept off of ballots. Is that essentially what they're saying here?
Essentially what they're saying is it's up to Congress to tell us how this works. So if Congress had, let's say 50 years ago, Congress had passed a law saying we're going to let the states do it, so long as they abide by due process, then what Colorado did would have been fine. But Congress has done essentially nothing in the 150 years since the 14th Amendment was ratified in 1868. Now, I want to make sure people understand this. It's a very important feature of this decision. There is no substantive discussion in here by the Supreme Court of whether Donald Trump did or did not engage in insurrection.
Interesting.
There is no conversation about what the meaning of his words at the rally were, or what happened inside the Capitol, or any of Donald Trump's actions. That's not what the Supreme Court has done here. That's not what the Supreme Court typically does. This is a procedural, legalistic decision. And essentially, if I had to boil it down to one sentence, it would be, it's up to Congress, not the individual
They didn't
states.
want a big messy situation where all the states go here and there and that sort of thing.
The word I circled in this decision is, quote, patchwork. They said, we don't want a patchwork where one state's doing one thing and another state's doing another.
But you know Donald Trump better than most, covered him for many years, as a reporter, covering him as a politician and as a figure who takes things and will turn them the way that he wants America and the world to see them. Yeah. I will be shocked if Donald Trump doesn't, as soon as he can, get out there and argue not only that the Supreme Court is behind him, but he's probably going to argue, even though there's nothing in here that specifically says, as Ellie so importantly pointed out, anything about what happened on January 6th. It's just procedural about whether the states or Congress have a right. He will claim victory, and I'm guessing he will do it in a more broad way than this decision actually says.
Yeah, and Joan, I mean, there are countless Americans out there who believe that the Supreme Court just bailed out Donald Trump here, and that they're going to bail him. They might bail him out again on the immunity issue, which I know a lot of folks feel like that's not going to happen. But the fact that can got kicked down the road means that the January 6th trial may not happen in federal court.
And what you're referring to there is the fact that the justices have scheduled an oral argument for the week of April 22nd on whether Donald Trump should be immune from criminal prosecution for election subversion. But let me just tell you what concerned the three liberals about this ruling and how far the majority went. And just reading it now, their concern was that the majority went further than they needed for this particular case and essentially is over-favoring Donald Trump. Ultimately, under the guise of providing a more quote, complete explanation for the judgment, the majority resolves many unsettled questions about Section 3, that's Section 3 of the 14th Amendment, the anti-insurrectionist ban. It forecloses judicial enforcement of that provision, such as might occur when a party is prosecuted by an insurrectionist and raises defense on that score. I mean, the language hints of what's happening with Donald Trump right now. So I think that's their concern, is that the fuller majority has gone further. Now, this is a concurrence, just so you know. So all 9 have signed on to the basic principle, reversing the Colorado Supreme Court and keeping him on the ballot. It's just about what happens down the road.